All right. Good morning. Good morning. Good morning to all. It is Thursday, October 3rd, and I'm more casual than normal today. But as it's August, when else can you wear a t-shirt at the office? Here you go. All right. And we are doing part two of our session. So part one was done before. You can find it on our forum, on our YouTube channel, and on all of our various social media. This is part two of the Form 100, 101, and 111. Thank you for joining us. Some preliminary matters, and of course, we'll start at the normal time of 10:05, so I get like 2 minutes to talk to you. First, want to mention that the forum is private. The videos are public. Anything you say can and will be used against you in a court of law. I don't know. It just seems to follow when you say anything you say to a large group. But actually, anything you say is going to be recorded and will come out on public forum. So just be advised of that. As a secondary matter, we have a couple of really good hard-hitting sessions that we're actually lining up for September. You can expect to see them shortly. I would, however, mention that this August, and one of the reasons we're doing this session right now, is that we are presently trying to track, as we do in August, for newer entrants into our profession, those people who are trying to get up to speed with basics, and those people who are searching for, well, what the heck am I doing here and how do I bring it all together? I mean, don't get me wrong, this is good for seasoned professionals too, but we really are trying to attenuate a lot of the activities that we're doing on the forum presently for new agents. And to that end, once this is done, I will be posting something on the forum. One of our new parties at our office is a law student who will be called to the bar in October, and she will be hosting a networking event for new agents and new lawyers to get together for drinks, summer drinks, shortly. So do look for that invite. It's a social event to kind of allow people to expand their networks, get to know one another. And because we're all good people who are part of this forum, and those of you who are watching this and are not part of the forum should join the Ontario Real Estate Legal Discussion Group, because it is good people and good forum. Strongly suggest that you come out, make your connections, make your friendships that will last a lifetime. This is a wonderful place if you know the right people. Okay, no, I apologize. I'm getting over a bit of a cold, so you may hear me hack a lung as I kind of go through. But with your permission, I am going to continue the fun. So last we spoke, we were dealing, I believe, with section 12 of the agreement. And I started rushing through, noticing the time before I decided to actually make this into a two-parter. And so I'm going to start again with section 12 here, and then we'll keep on going through the forum, and then I'll turn my attention to 101 and 111 and what the differences are. Section 12 is one of those sections that everyone disregards. And that's possibly because it has the longest sentence in human history that has ever been constructed. It's actually comical. If you want to read someone the longest sentence that grammatically is correct, but makes zero sense, you have to read them the sentence that begins with this one here. This is literally a single sentence, this entire thing. And rather than read the whole thing and laugh at the fact that someone was able to put it together, I'd like to describe what it says. It says that if a buyer and a seller, if you think about it, let's just think about the way a transaction happens on the day of close. On the day of close, the seller is demanding clean title. That is to say, no one's mortgage on title. And yet, the buyer is demanding clean title from the seller. And yet the seller is only getting the buyer's money at 4:59, 4 o'clock, whatever it may be. That's when the buyer transfers the money over to the seller. At that point, TD Bank, who holds a mortgage on the seller's property, is not releasing its interest, nor is there any conceivable way of getting the money over to TD Bank that same day and having TD Bank discharge the mortgage. What does that mean? That means that when the buyer registers its interest at 5 o'clock on the day of closing, it is doing so even though the seller's TD mortgage is still on title, practically. And the OREA form says that is okay, so long as you have a payout statement showing how much is paying, how much is due and owing to the bank, and you provide that payout statement to the buyer, and the solicitor provides an undertaking, which is a signed promise backed by our insurance, that we will pay off the mortgage in accordance with the discharge. That's all well and good. What does an agent need to know? An agent needs to know that a buyer has to accept that undertaking unless the bank that holds the mortgage is a private mortgage. That is to say, if the mortgage doesn't come from TD Bank or Caisse Populaire or Credit Union of the Kawarthas, all of which are acceptable financial institutions and are listed in Offspree's Form 1. I could go into that, but who cares? If it comes from Uncle Bob, or if it comes from a professional corporation, or if it comes from somewhere like that, the buyer's lawyer does not need to accept, nor will they accept, an undertaking and a payout statement. Instead, either the mortgage has to be paid off on the day of closing, or lawyers have other magical ways of taking care of the mortgage on title through three-way DRAs and other ways that are beyond the scope of this session. The high-level lesson from Section 12 is this, because I've spoken a lot about this. If you are dealing with a seller that has a private mortgage, please alert the seller's lawyer to that fact early on. Now, the seller's lawyer will figure this out, of course, but there is a lot of extra work that has to be done to pay off a private mortgage when you are acting for a seller, as opposed to a TD mortgage where a simple payout statement and an undertaking to pay out that mortgage is sufficient to close the transaction. In fact, the buyer cannot stop a closing if those two documents are provided. Now, I know that that's really complex and really delves into the weeds. So again, from a realtor perspective, all you need to know about Section 12 is if there is a private mortgage, please flag it and note it to the seller's lawyer if you are acting for a listing party. That's what it means. If you're making notes, that one sentence is it. If there's a private mortgage on title and you know about it and you're acting for the listing brokerage, please flag it to the lawyer. There's more work for them to do. I'm going to pause because that's probably the most complex and convoluted portion of this agreement that most people don't understand. Does that all make sense, Section 12?
Yes, and I think that it's important for realtors to understand that, number one, if it doesn't close, if you did not advise the lawyers and it doesn't close, you're not getting paid, which is why you're selling real estate. But also, someone is going to be in breach and it's going to be a mess. So
Correct.
this is very important.
Although I would point out that in this instance, it would fall squarely on the shoulders of the lawyers. Because the lawyer, of course, for the purchaser has the obligation to search title 2 weeks in advance and alert the seller. And the seller has an obligation to actually know what's on title and discharge it. So this is squarely within the job of the lawyers, not the realtors. Having said that, I'm saying if you do know about it, just give the selling lawyer advance notice because it's going to be something substantive that the selling lawyer has to deal with. But totally agree, Sandy. By the way, Sandy, I made you a co-host here. Just so
okay, thanks.
All right.
Yep.
All right. Let's move on to Section 13, inspections. So the buyer acknowledges having had the opportunity to include a requirement for a property inspection, and they have not obtained it unless it is otherwise stipulated in Schedule A. All right. They also state, and this is very interesting, that upon acceptance of the offer, there shall be a binding agreement of purchase and sale between the buyer and the seller. That's it. It's done. What this means in law is as follows, and it's a bit beyond the scope of today's session, but I'm going to go into it. In the event that you do not request an inspection, then you cannot complain about defects that exist at a property except in very specific circumstances. Those circumstances are where there is a latent defect that was known to the seller that was not disclosed to the buyer. A latent defect is something that's not patently obvious on reasonable inspection. So if there's a giant crack in the ceiling, that's patently obvious. But if there was a giant crack and then it was drywalled shut and it was known to the seller and the seller didn't disclose it, then that's a latent defect. So what this says is you are taking this caveat emptor. You're taking this, you have had the opportunity for an inspection. You've either chosen to opt for it or not, but this is binding. And the defects that you may find at the premise, you cannot sue for. Again, short of latent defect, or, and I'm just going to bring this up because it's an appropriate point, or for defects that have arisen after the agreement of purchase and sale has actually been entered into. It is the case that there is a concept in law called equitable conversion. And what equitable conversion means, it's fancy talk. And what it means is that the moment you sign your agreement of purchase and sale, you are the owner at law. I know that's not the way we all think about it as agents. We always think of the closing date, and that's when we become the owner. But that's not correct in law. What happens is the moment you sign your agreement of purchase and sale, bam, you are the owner at law. And this agreement says that the seller shall maintain the property in its present condition in trust for the true owner at law. And as a result, if damage occurs after the agreement of purchase and sale is signed, then there is an obligation to deliver the product in the state that it was contracted for. So let's take something that isn't real estate based. Let's take a car as an example, a used car. When you go to a used car lot and you see a car with rust and you say, I'm ready to pay $5,000 for that Toyota Corolla, that at the time of purchase was probably 30, but now it's 5. It has rust, it's old, whatever. When you take possession of the car, are you allowed to say, that car has rust, I want you to fix it for me? No, of course not. Because what did you buy? You bought a used car with rust. Still has value, still has $5,000 worth of value. It's not 30, but there it is. But if you go to a used car lot and you say, I'd like that car with rust, and it has like shiny hubcaps on it, and then it's delivered to you, and you sign your contract and everything else, and it's delivered to you and the hubcaps are gone, is that acceptable? No, because you purchased the car, even though it was used, you purchased it with those shiny hubcaps. And thus those shiny hubcaps have to be delivered. So understand it from the perspective of a car. If you are contracting for X, you get X. And so it is the case that we often have instances where there are floods, or there are fires, or there are problems that happen between the time the agreement of purchase and sale happens and it is closed. Well, do you have to disclose that personally? No, there's no need to disclose that at all. You have to disclose latent defects. If you fix it fully through insurance, is it a defect? No, it's not. It's not a defect. I'm delivering the exact same product. If someone goes ahead and steals the hubcaps from my used car and I replace them with an exact same set of hubcaps, do I need to tell you that they were stolen? No, I'm still delivering to you the exact same product you purchased. No problem. If, however, there was a flood and you didn't fix it up 100%, is it a defect? Yes. Are you getting what you contracted for? No. If I put substandard set of hubcaps on the car, is that something I need to account for? It is. It's really helpful to think about this from the perspective of a car lot. It makes it much easier. I'm going to pause. Does that make sense? Okay. Section 14 directly plays into the concept of equitable conversion. Because you know how I said at law, it is the case that the buyer becomes the owner of the property the moment the agreement of purchase and sale is signed. The registration and the access to the property happens on the closing date. Well, if that's the case, then technically the buyer would have to maintain insurance on the property from the day it's signed because it's their property. But the OREA form reverses the onus. And what it says is it says that the seller will continue to maintain its insurance up until the day of close. And it also says something else that's interesting. It says that the seller shall hold all insurance policies effectively in trust for the buyer. The buyer may terminate if there is substantial damage at the property. The buyer may elect to terminate this agreement or take the insurance proceeds. I was once a lawyer on a property that was scheduled to close on Roberts Road down in Toronto. It was a series of old townhomes right by U of T. And 4 of the townhomes went up in flames after the agreement of purchase and sale was signed. You know what my buyer did? Well, He didn't find out about it until after. But you know what my buyer would have done if he had found out about it and spoken to me? If he had said, Mark, my place is up in flames, what do? I would have said, here's what you do. You go to Loblaws and you buy that popcorn, that kettle corn, by the way. Don't buy any other flavor because the kettle corn flavor is the best flavor. I know some people think the extra butter and the salty thing. No, it's kettle corn, guys. So make sure that when you're in Loblaws aisle, it's kettle corn. So you go to kettle corn, you buy that, you pop it in the microwave, you pop that popcorn, then you get your nicest, fluffiest lawn chair, and you set it out right by those homes, and you open up that bag of kettle corn popcorn, and you just start popping and eating it. And you cheer. You cheer as the house goes down. Why? Because your old home is subject to an insurance policy, which you are going to get the benefits of. And what's going to happen is you're going to get a brand new build from the insurance policies maintained by the seller, and you will be golden because you are allowed to elect to either walk away or take the insurance proceeds. That's the way this is structured. Does that make sense? Okay. The Planning Act. So I kind of prefer to skip this because this is really beyond the realm of people who are starting into the Form 100, 101. Suffice it to say, all sales have to conform with the Planning Act. That is to say, if the city is worried about people subdividing their lots into ever smaller size, and so you need municipal permission to sever a lot. And what this is saying is that you shall comply with municipal permissions. I'm going to leave it at that, and you can just please don't cross it out. That's all that I would say about that. Other than that, your lawyers will deal with this. Okay, now the doc prep. So the transfer deed is prepared by the seller, and the seller covenants that the deed shall contain all of the Planning Act statements. That's all that this is saying. It's saying which of the lawyers are preparing what documents at the back office. Just don't cross it out. You're fine from a realtor perspective, no problem. And then we have residency, and I'd like to talk a bit about residency. I talked a bit about this when I was dealing with the HST in the previous video, but I'm going to talk about this now as well. It is the case that you have an obligation when you buy anything from anyone to verify that the seller is a resident of Canada. And I mean that. If you're at a garage sale, technically, and you buy like a little stroller from that garage sale, you have an actual legal obligation to ask the seller, are you a resident of Canada? And can you please provide me with a statutory declaration attesting to that fact? Now, none of you are going to do that because you're going to be punched in the nose. I mean, it's as ridiculous as the seller turning to you and say, I have a legal obligation to charge HST on this used stroller, which in fact they do. They actually do. They don't practically, but they do have that obligation. Having said that, the statutory declaration is important for the purposes of real estate and is enforceable. What it means is that if a non-Canadian, for tax purposes, not citizenship purposes, tax purposes, if a non-Canadian is selling property for tax purposes, sorry, and they are non-resident for tax purposes, so they're living in Saudi Arabia for 2 years or whatever it may be, then the buyer has an obligation to withhold 25% of the purchase price for residential properties, 50% of the purchase price for commercial properties, until such time as the seller has either received a compliance certificate from the CRA or has signed a statutory declaration stating that they are Canadian residents. What does this mean for an agent? It means that if a seller tells you that they are non-resident, first thing you do is you say, all right, let's have your accountant verify this, because your accountant is the one who will tell you if you're a resident or not for tax purposes. And if they say they are non-resident, and you should immediately contact a lawyer before you sign your agreement and ask them for advice. But practically what the lawyer is going to do is they're going to say, all right, is this a residential property properly? Okay, 25% has to be withheld. Let's see what the amount of mortgages are that are on title, and let's see what the commission payments are. Because it's critical that we have sufficient equity in the property to withhold 25%, pay off the mortgages, and pay off the commissions. Otherwise, if I'm withholding 25% and you owe 80% loan to value on your mortgage, how do I pay it off plus the commissions? I can't. You see the problem? So from an agent's perspective, what you need to know is that if a seller is telling you they are non-resident, immediately get in touch with the lawyer. Don't even remember what I'm saying. Just say, I remember there's something about this. Oh God. Go to your lawyer, and that lawyer and you will work through a title search and verify that there is sufficient equity in the property to sell the property, such that you do not end up in the position I've seen 2 or 3 times in my career where someone has sold a property, we've discovered they're non-resident, and there is too many debts to pay out once we account for the 25% holdback, and it torpedoes the deal. Does that make sense to everyone? Anybody have any questions? I'm going to pause for a bit. I think that there is a chat question. Let's see. Kettle corn. Someone said kettle corn. Shama, that's the most important comment that will be made today. Anything else, guys? Okay, cool. Let's keep going. Done. Am I on the right thing? Yes, I am. Okay. Now the adjustments. Please don't cross this off. And what it says is we are going to adjust and we are going to make it so that the buyer is responsible for the day of completion. We're going to adjust for condo fees. We're going to adjust for taxes. I mean, not condo fees, because this is the Form 100, not the 101, but it says the same thing in the Form 101, and for that we adjust for condo fees. We're going to adjust for taxes. We're going to adjust for fuel oil. That was a much more important thing before before 2006, when there was a change. I don't need to go into it. Effectively, we are going to up or lower the purchase price by the amount of overpayment or underpayment of taxes and condo fees, such that we are apportioning for the day of close. That should be, I assume, understood. Next, property assessment. It is the case that taxes in Canada are determined based on MPAC's assessment that happens every 4 years. Hasn't since 2016 because of COVID, but usually it's every 4 years. That is to say, every 4 years, every parcel of land in Ontario is assessed at a value. And when that value assessment takes place, because it's that assessed value times the mill rate that determines the tax payable on the property, it's very possible that your taxes will go up hugely. So as an example, if someone has done renovations in the past year and MPAC comes around and reassesses the property and says, hey, this property we originally had valued at 1 million, but it's now worth 2 million. You're now taking 2 million times the Toronto tax rate, which I think is 0.61 or whatever it is, 0.59. But you're now taking 2 million as opposed to 1. Your taxes are going to double. Well, you can't come back to the seller and bother them about that. It's just not allowed. That's the way this goes. And that's what this says. Next, time limits. This is really a critical line, even though it doesn't seem like it. It says the time shall be in all respects of the essence. What that means is that if you, and the case law has borne this out, if you are 1 minute late in the performance of your duties, it is a fundamental breach of this agreement. There are different types of breaches of an agreement. I use this example all the time when I teach down in law schools. And it goes like this. If I, as a young single man, P.S., that's not what I am, as you can hear from the hacking in my lungs right now. But if I was a young single man in my 20s, and I walked into my Yorkville car dealership, and I walked into that Lamborghini place and I said, I want that red Ferrari. Everyone understands why I want that red Ferrari when I'm in my 20s and I'm going into that Yorkville place. And I'm going to contrast that before I go on with the story with me in my present state, Mark Morris approaching 50, who has children and a wife and walks into a used car dealership and points at a minivan and says, I need a minivan. And they say, well, this minivan is this feature or this feature. I said, all I care about is the cup holders. Just give me that minivan. That green one will be fine. Thank you very much. Now, day of delivery happens for both cars. Mark Morris, the 50-year-old, walks back into the car dealership and they say, all right, here's your minivan. And I look at it and it is red. It's the same minivan. It's red. Is it a breach of the contract? Yeah, clearly, I purchased the green minivan. Is it a fundamental breach of the contract? Is it fundamental? Was it essential to what I was contracting for that I was getting a red minivan or a green? I didn't care. My life is over, right? Like I'm done. That's it. So no, it wasn't fundamental, and thus I may be entitled to monetary damages. But Mark Morris, the 20-year-old, Mark Morris, the Tinder maven, who is getting that red Ferrari. When Mark Morris, the Tinder maven, walks in and gets a green Ferrari delivered, fundamental to the contract? Yeah, because we all understand why Mark Morris, the 20-year-old Tinder maven, wants a red Ferrari. It was very important to the contract. We are stipulating in this section 20 what is important to the contract. And what is important? Time. Time is the red Ferrari. It's not a green minivan. It's a red Ferrari. It's the Ferrari. And as a result, if you violate time in this agreement, you are out. You have breached the agreement. Where does this time play into things? Well, first, Sandra, hit it up. What's the first one? Come on, I'm going to highlight it for you so you can say it. What is
I've been waiting for this. I've been waiting for this one forever. Loblaws. You cannot be late.
Right.
The buyer created the agreement, and they included the term time shall be of the essence. So, as judges say, the onus is on them to obey their own requirement. Loblaws, they've got lawyers coming out of the wazoo, very good lawyers, but they still lost because they were late on the deposit. There is another lawyer well known in Toronto, and he put up a video about this. His agent, the listing agent, drove out and picked up the certified check for the deposit. Or sorry, the buyer's agent picked up the certified check for the deposit. He stopped and had lunch with a buddy. He took it to the listing brokerage, and it was 25 minutes late, past the 23 hours and 59 minutes. What happened? Seller got another offer higher, and they resold it.
Correct.
Now, you might think that that's not a problem, but if you then have to take that buyer, the buyer paid $1 million for that house. Prices are going up. You have to take your buyer shopping again after you've told them that you screwed up and stopped for lunch. Now they have to pay 1.2. Guess who they're going to sue for the $200,000?
So Sandra's exactly correct. There are three fundamental points where time is of the essence in the contract. One is the deposit, two are the conditions, and three is the closing. If you breach any of those times by a minute, because we are stipulating that time is of the essence, it is a red Ferrari, not a green minivan, you are out. That, and what Sandra was talking about, Loblaws, is a case called Jackson v. some numbered company. And what it was Loblaws was literally late with the deposit, and time was of the essence. And the judge said, sorry, Loblaws, you're SOL. Make sense?
Yes, and Loblaws appealed that, and they still lost. And also, just to remind agents that late is late. It's like, you can't be just slightly pregnant. The original case was Union Eagle versus Golden Achievements based in Hong Kong Privy Council. And they were late for the closing by 10 minutes on a $4 million condo. And the judges refused to determine late is late. They just said 10 minutes, whatever it is late. So agents, you cannot be late.
Now, if you are running late, because it does happen to all of us, what you're going to do is you're going to write immediately to the other lawyer, other agent, and you're going to say, be advised, I'm running slightly late. Is it okay for me to deliver this check at this time? And if they say yes, then they will be stopped from denying the acceptance of the check. So if you can get the other side to agree to you bringing in the check late. That will be a defense in court. But absent that, be advised, time is of the essence. So it's strange because everyone really ignores this line, but it's actually the heart of what constitutes so much of our agreements of purchase and sale.
Mark, may I
Yes.
ask a question?
Yeah.
I just want to ask, because this has come up several times lately, so that we can clarify it anyway. In regards to timing on the irrevocable on the offer, I'm finding so often people are responding beyond the irrevocable time. And it's my understanding that as long as both parties agree to keep the offer alive, then it can stay alive in that case.
Excellent.
Is that correct?
It's an excellent point, Jay, and I'm going to go into that in some detail now. You'll note
Okay.
I said 3 things are mandated by time is of the essence.
Right.
And I didn't say the irrevocable, did I?
Right. No.
And the
That's
reason I didn't say the irrevocable is because, and this is for the new agents out there, is because there is a huge misnomer that takes place. In fact, if there's one thing we can collectively do, it's rid our terminology of the word counteroffer. The reason an irrevocable can fail, and the reason that it has no bearing and that it's not a time was of the essence issue, is because when the irrevocable passes, the deal is in fact dead. It ends. But there is no such thing as a counteroffer at law. There is only a new offer at law. And as a result, when a sign back takes place, that's what we call it. A sign back insinuates that there's a continuation of this previous contract, but that's not what it is. It's not a sign back. It's a brand new contract that is extended back when it is a countersign. So we call it a countersign, but actually what it is the offer died, and I'm reasserting a brand new offer to you. And that's the reason it works. It's for a different reason. The time is of the essence is once you have a contract. The irrevocability clause, if you go beyond it, means that thank you very much, this deal is dead. But because this person is signing it back, technically, what they're doing is they're reestablishing a whole new offer process to the other side, which they can accept, forming a new contract. Does that make sense?
Yes, thank you very much for that. So there's no need to send a new page extending the irrevocable time limit on.
Absolutely not, because when
Yeah.
you sign back with a new irrevocable period, you are extending a brand new offer.
Great. Thank you very much for clearing that up.
Okay, I know someone else on this channel has that very question because we just dealt with it yesterday. So this is obviously something that is going around and there's some misperceptions as to what's taking place. But that's the reason time is of the essence doesn't apply to the irrevocability period. Clear?
Great. Thank you so much. Clear.
Okay, very good. Anyone else have any questions so far?
Mark, can you please cover to them that the seller can't accept it outside of the irrevocable time and still call it a firm deal?
No, once the irrevocable, let's take a look at the irrevocable, and I talked about this last session, but the irrevocable says this offer shall be irrevocable until this, and if it was just at that period there, then it could still be accepted. But there isn't just that. It also says, after which time, if not accepted, this offer shall be null and void, meaning the offer is dead. If you don't accept it within the irrevocable period, it's dead. If there wasn't this line, then no problem. You have until it's irrevocable until this time, sure, but it remains open for acceptance until I revoke it. But in this instance, it remains open only for the irrevocable period, after which it's null and void, and then no, it cannot be accepted at that point. Clear? Coolness. I'm sorry about the cold, guys. Okay. Family Law Act. Seller represents that the spousal consent is not necessary to this transaction unless the seller has executed the consent. So let's get into this. Spousal consent. What is a spouse? God darn it. It is tough to understand what a spouse is. And if you're confused, please visit our previous videos on this subject. But let me be very clear for all of you here. The Oberfeld decision in Canada, which established gay rights, was fought on the basis of the fact that married spouses are different than common law spouses. And if you deny gay people the right to be married, you are denying them their four fundamental rights. When you are a married spouse, you have two rights that common law spouses do not have. The first is the right to sit your bum in the house and not move. The second is a right to the equalization of the full value of the home, even pre-marriage, for marital homes. You can watch our family videos on this if you have any questions. The be-all and end-all is that agents get this confused all the time because they believe that if you are a common law spouse, which they deal with regularly for land transfer tax, then you have to sign this. That is not the case. It's only married spouses that have to sign this. The Family Law Act, confusingly, gives two separate definitions of spouse. The first is the one found in the definitional section of Section 2, which says married spouse, people who are married. The second is for the purposes of land transfer tax qualifications and NRST qualifications, which defines a spouse as someone who's married for 3 years or more. Because you as agents deal both with land transfer tax issues and with the spousal signature here, it's conflated all the time. I don't know what a spouse is. I hear this 3 years common law partner is a spouse, and I hear that married spouses are also spouses. I don't know. So very clear. For the purposes of this signature, it's a married spouse because only a married spouse has the spousal right of possession, which is the right to sit your bum in a home and not move. For the purposes of land transfer tax, which is beyond the scope of today, and NRST, it is a common law spouse defined as someone who has been together for 3 years or more or has a child together. That's what the definition is under our Family Law Act. There's actually, to confuse matters even further, a further definition of spouse, the federal definition of spouse. The federal definition of spouse under the prohibition on purchasing property is 1 year of living together. But again, from your perspective, what you need to understand is only married spouses sign this section. Cool? All right, UFI. I don't need to go into it. UFI is like asbestos. It's just this thing in the past. We still have it here. You're representing, you don't know of any UFI, you're done. If your seller says, I think there may be UFI, you cross it off. All right, so buyer is hereby notified that a consumer report containing credit or personal information may be referred to. Why would a seller care about getting a consumer report on a buyer? What circumstance? 2.
VTB.
VTB, you may want to know who it is that you're lending to. And 2, rental, right? If whatever it is, if you're arranging some form of rental or anything else, you know, before this actually closes or a rent to own or something else, you may want to find out about the buyer. And this gives you that consent, which consent you need if you're to actually pull a credit report. All right, Section 26. The agreement is to be in writing. Moreover, the common law principle that anything contained outside of the standard provision takes precedence over the standard provision applies. So, as an example, when someone is assuming a property with a tenant, they usually put that in Schedule A, right? They usually say buyer agrees to assume the tenant, yada, 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 which is paying the following. Okay, they generally do not cross off the completion. Remember this little line here? Upon completion, vacant possession of the property shall be given to the buyer. And so most of the agreements that come into my office contain a clause that says the buyer shall assume the tenant. And there's also a clause that says, and by the way, vacant possession shall be provided to the buyer. Those are two contradictory clauses. Not so, because Section 26 says if there's any conflict or discrepancy between Schedule A and the standard form, then the Schedule A, anything that is pre-printed, is secondary to those things that have been agreed to by the parties. I have successfully argued in small claims court that there is a precedence to, the small claims court isn't binding, that there's a precedence to the order of things in the agreement. And I've successfully convinced the judge once, who was very smart, this was about 10 years ago, that the order goes, first comes Schedule A, then comes Schedule B, then comes the pre-printed form, because I once had an instance where Schedule A was being argued against Schedule B. And I was able to say Schedule B is actually very similar to the pre-printed provisions because it was drafted by the listing brokerage in advance of anyone actually coming to terms or negotiating this contract. And thus Schedule A changed Schedule B, and Schedule B should be seen as pre-printed forms. And the judge agreed with that argument. I'm not saying to you that that's binding. I'm just saying to you, you could think through the way that this kind of works. It also says everything needs to be in writing. 1666 was an interesting year in real estate law. Yes, 1666. Because it was in that year that the statute of frauds was implemented in Britain. It was the case that fraud was endemic in Britain, and a lot of people were getting people drunk and making verbal agreements on a handshake while people were intoxicated, saying, I'll give you this apple for this piece of land, let's shake on it. And people were losing their shirts. And as a result, the legislature of the time passed the law that said, for the purposes of marriage, divorce, and the sale of land, everything needs to be in writing. And that became basically the default for the entire common law world and continues to exist today. The statute of frauds remains. What it means is that any sale of land, note, I didn't say lease of land. Lease of land is fine. Any sale of land must be in writing. And thus, anything you say is puffery. That's what it's called in legal jargon, for those of you who are still in first year law school. If you go ahead and you say to someone, yeah, I'll sell you my land for an apple, but you don't put it in writing, it has no bearing and the courts won't enforce it. It must be in writing. And thus it is that all things must be in writing between the clients. Now, there's an interesting question as to what is in writing, but text messages have been found to be in writing now. Emails have been found to be in writing. These things are in writing. It's acceptable under the Electronic Commerce Act. So really what we're saying is it has to be recorded in some form of physical sense. Electronic bits are physical sense. Does that all make sense?
Yes, it does. Mark, can I ask another question?
Yes.
In regards to the Schedule B, and this may be another whole presentation by you, but it seems Schedule Bs are getting very long and detailed with a lot of stuff, and I don't know if it's all from the brokerage or from the agent or what, but I think it's getting a little bit confusing as to all the details that are on Schedule Bs today.
Just bear with me. I'm going to answer that in 1 second, Jane. Okay. I just want to make one point just before I get off 26, and then we'll go to Schedule B.
Okay, thank you.
For 26, I want to point out that though things are in writing through text or email or anything else, there is a different provision in Schedule 26 that says, this agreement, including any schedule attached hereto, shall constitute the entire agreement. So it's all well and good that something could be in writing electronically through text or email. But the only thing that has consequence is this agreement or associated schedules. And so it's really critical from a compliance perspective that if you have an agreement, that it be included as an amendment to this agreement, not be something on text or email. That's where I wanted to finish off. So it's very good. It's valid. It's pursuant to the statute of frauds. Electronic communication is valid. But because of the entire agreement clause contained here, all amendments that are agreed to have to be formal amendments or have to be added to a schedule. That's the way to understand Section 26. Make sense? Okay, Jane, let's turn to your Schedule B. So you're correct. Schedule Bs are now turning into like 1, 2, 3 pages of errors. I agree. What's your question about it?
I'm not even sure if I know the right question to ask. It's just that there's so many details on there. You just laid out that Schedule A takes first precedent in the offer and Schedule B takes second precedent, and then the details in the body of the offer take precedent.
That's my reading of things, not enforced. There's no case law on this yet. So that's my that's what I would think would be a reasonable thing. And Schedule B would take, it's only if Schedule B is directly conflicting with Schedule A that Schedule A takes precedent over Schedule B.
Okay.
All right. Yeah. And it's if Schedule B is conflicting with the standard form, that Schedule B takes precedent over the standard form.
Right. The attachments take precedent.
Correct.
And I guess, I mean, there are just so many different Schedule Bs out there. There just doesn't seem to be any rhyme or reason as to what can or should be on a Schedule B. And I'm not sure again, questioning, you know, what legally is or should be, or
I
should we
personally hate
scratch off,
Schedule
or-
Bs. I hate
Pardon?
Schedule Bs. I
Yeah.
really dislike Schedule Bs. I think that, frankly, anything that is standard should be part of the OREA agreement. And if there's things like, okay, there's commissions or interest payments or anything else, friggin' put it in, or negotiate this actively as part of Schedule A. That's my personal take, but that's
I
not what the
agree.
industry has
Yeah.
done. That's
Let's
not what
keep
the
off
industry has done.
details on-
Industry
yeah,
has
let's keep
Schedule B. And so really what you need to do more than anything is you have an obligation as an agent. Schedule Bs are not complicated in terms of legal language. They're not like Section 12 of this agreement that require a lawyer to explain them.
Right.
You can understand them, but you have an obligation to ensure that you are reading through every paragraph of Schedule B with your clients, because it could substantially change the agreement. Very important.
Right.
One thing that realtors need to understand is if it is not initialed when it is uploaded, the Schedule B can be changed. You do have the right to just retype it and leave out what you want or put in what you want. I did that on a power of sale. The lawyers for the Royal Bank of Canada were not happy when they discovered a month after we were firm that I had changed a paragraph, but I had an obligation to represent my client properly, and their clause only represented the seller.
Correct.
So you can go through it and make changes.
And you can similarly change the standard form on the form 100, 101, or 111, but don't you dare. I cannot stand when people change it. Do not change it without legal advice. If your lawyer is telling you to change it, that's one thing. Do not change the standard form for 100, 101. But Schedule B is just something that they wrote up. Feel free to change it. We'll change it with reckless abandon. It's up to you. Go ahead. No problem. Okay. So that brings us to the witness. You actually don't need a witness any longer. You never did, because it's signed under seal. Plus, Electronic Commerce Act has the certificate of compliance. So the witness is no longer really that important, but you can put it in just to make ourselves feel better. The confirmation of acceptance, you can speak to your broker as to how the signing takes place, and you can move forward. And I'm going to bring this to an end just because I'm running out of time and I have to turn to the form 101 if you do not mind, which I'm going to do right now. Where is the form 101? There we go. Here's the form 101. So I'm going to only go over those provisions that are different in the form 101. Okay. Everything here is the same. Common expenses. The seller warrants to the buyer that the common expenses presently payable to the condominium corporation are approximately X per month, which includes the following. So what happens if they're different? They're often different. Sometimes you find that they're different. Now, the first thing is you have to figure out why the difference. Condo corporations raise their fee once a year, not necessarily on December 31st. It's at their year end. So if someone lists on MLS that my fees are $530 and you find that they're $546, it could very well be because in August 1st, the price is raised by $15 for this year, and they were representing and warranting last year's time, and now it's this year's time, and that's just acceptable. There's no problem there. The representation and warranty, however, does in fact take hold when you are massively wrong, if you're off by $90 or $100. And agents being agents and lawyers being lawyers, both of us have never really excelled, if you will, at financial math. But I'd like to just quickly show you what that can run to in terms of error. Because what most people do is they say, okay, it's $100 a month. So let's just take 100 and then multiply that by 2 years. And so we're going to have $2,400. And the reason that they do that is because they don't understand basic financial math. But actually, if you actually understood financial math, you would take the present value of a discount rate. What you would do is you would say $100 a month times 12 is $1,200. That's the net amount more I need to pay per year. I'm going to divide that by a discount rate. That is the cost of money over time, if you don't understand it. So I'm going to divide it by 0.06, let's say. That comes to $20,000. Another way of thinking about it is if I have a bank account replete with $20,000 in it and I earn 6% per year, it will pay me $100 a month, meaning I will be made whole by this $100 discrepancy only with $20,000 of reduction. Most agents, most lawyers don't understand how to work out this math because, again, they haven't worked out financial math in their life, but they really should. And if I had to go to court on this, I think I'd be able to prove to a judge that I need $20,000 sitting in a bank account to produce $100 every single month, such that I am getting what it is that they represented and warranted. Done. Could be big. Okay. I'm going to point out something else. I'm going to go back here. I'm going to point out that there is two different types of ownership that are contemplated in the agreement. One is called exclusive use and one is called assigned. Three actually, and owned. There are three different types of condo ownership. One is something that is separately pinned, can be paid for separately. Two is something that's exclusive use. So you have a property and it has a parking spot associated with that property. It's exclusive use. Every time the property itself is sold, it comes with that parking spot. I can't sell that parking spot separately. And last, the sign just means the condominium corporation owns it and they've assigned it to a unit. But both exclusive use and assigned property are often not found in the status certificate. And you need to call up the condo corporation to determine that exclusive use or assigned property exists. More often than not, condo corporations are now dictating when something is exclusive use. I'm just pointing it out that when a status review is done, it's often done without knowledge of the without reference to a parking spot or a locker. And that doesn't mean that it's not owned by the seller. It could just mean that it's assigned or exclusive use. All right, let's keep going. So title search is the same, closing is the same, common expenses we dealt with. Then we have this section 13. We have something that says seller represents and warrants to the buyers that there are no special assessments contemplated by the condominium corporation. There are no legal actions pending by or contemplated by the condominium corporation. The seller consents to a request by the buyer or the buyer's authorized representative for a status certificate, and the buyer acknowledges that the condominium corporation may have entered into a management agreement for the management of this condo property. If an agreement is conditional upon a status review, I believe it is the case, although there's no case law on this, that you cannot, after having had a status review and signed off on it, you cannot then claim that the seller has represented and warranted that there is no litigation or special assessments if there was knowledge of that fact in the agreement, in the condominium corporation, and it was reviewed, if it was a status certificate and reviewed. This is primarily because you have accepted that. It was disclosed to you. Prior to the offer going firm, it was disclosed to you. This is my personal reading on things. It isn't affirmed by case law yet, but I think it's a reasonable reading of the matter. This is different than if you don't get a status review, and then later on, prior to closing, you find out that there are special assessments or there are legal actions pending, in which case you can sue the seller. Of course, you cannot sue the seller. There is case law to the effect that representations and warranties made in the course of an agreement of purchase and sale are valid only as of the date they are made. They don't carry through to closing. They exist as of the time it was made. So if, as an example, you have a 6-month closing date, and on the day the agreement was entered into, there was no special assessment contemplated, but the special assessment arose after it was signed, there is case law to the effect that says that all representations and warranties in the agreement of purchase and sale pertain to representations and warranties as of the date the agreement was signed. Though, for this particular section, I know of no case law that has tested this fact. Does that make sense? Just an interesting point. Okay. Next. Same meetings. Seller represents and warrants to the buyer that at the time of the acceptance of this offer, the seller has not received a notice convening a special or general meeting of the condominium corporation, respecting the termination of the property, substantial alteration, or substantial change in the assets or liabilities of the corporation. Okay, that should be obvious. But basically, condominium corporations can fold themselves if 80% of the condo votes to fold themselves, or they may be expropriated by Metrolinx or God knows what, and there could be a huge expropriation taking place. If, in fact, you discover that during your title search, the buyer has recourse. If you're dealing with a co-op, oftentimes it is the case that you require board consent. Board consent is, in fact, a requirement. If it is a requirement, then this agreement becomes conditional upon the board's consent. And other than that, I'm going a bit fast here, but other than that, the condominium corporation document is largely the same. Let me deal with PODLs because I don't want to have to do a session 3. PODL has its own form. Most people don't know that, strangely, until you deal with a PODL. But be advised that there is this form. This is not it, so that's not very helpful to you. There is a special form. It only came out in recent years, and it's called the Form 111. It is the case that municipalities don't like taking on new costs. And so when someone builds a subdivision, the municipality says, we'll give subdivision approval to this so long as you take on the cost of the road. You can have a freehold home, but the road, the snow clearing, the electricity, the sewage maintenance, all of that is maintained by you at the rate of $100 to $200 per month. When that happens, you use a PODL agreement. A PODL is dealt with like a status, like a condo, because it is a condo. It has a condo component, but only for the portion of the property that pertains to the common element, which is the road, usually. And I'm just pulling your attention to the fact that there exists this thing called a PODL, and almost everything that is contained in the agreement remains covered by the Form 100 or the 101. I just want to point out that you should be using your PODL form, your Form 111, when you are dealing with a PODL, not a condominium form, which we see all the bloody time. Please do not do that. Okay, I'm turning to questions. I'm going to go 5 minutes over because it's now 11 o'clock. So let's just turn to some questions because I'm going to wrap this up. So Oliver, you wrote, Mark, you mentioned not to take out or change the pre-printed clause on Form 101. I've seen in some cases, especially power of sale, where the banks are crossing out specific points. Is this okay, or should the other? So what I said to you is, you don't do it. I said, if the lawyers are advising you, that's different. And what's happening with power of sale is the banks and their lawyers know how to revise the form to their favor, and they're doing so. If you have any questions with regards to that, bring it to a lawyer who's familiar with POSs, and we will verify what's going on. A lot of the changes that are being made with a POS, with a power of sale, is being done by virtue of the Mortgages Act. The Mortgages Act empowers a lawyer who is acting on a first position to discharge and get rid of the second, third, and a whole bunch of other subsequent interests on title. And as a result, the Section 10 of the agreement can be substantially altered, as can a lot of the representations and warranties. Again, if a bank is changing it, bring it to your lawyer and have your lawyer verify that it is kosher. As agents, please do not willy-nilly change Section 100 or 101 because you don't understand it or you believe X. Please get your lawyer's approval before you change it. That's all I was saying, Oliver. Gil writes, question regarding irrevocable. If I sent a buyer offer, the offer expired, the listing agent sends me a counter. Okay, we already dealt with that, Gil. So the answer is every new offer where you change the irrevocable, every time you countersign, it is a new offer. Okay, so any other questions for me? Let's turn it open. We have 4 minutes. 4 minutes and then quick stop. Shout them out.
Good morning.
Sorry.
Hi, this message to you, and this question is to you, Mark, and probably Sandy. Multiple offer situation. I accept an offer, and now the buyer is late on the deposit or doesn't show up, and I don't have a recourse. I can't track them on Geo Warehouse. First-time home buyers. Is there a best way practice to kind of nail their information down on the offer presentation time?
On the offer presentation time, not really, but remember that per Section 3 of the agreement, all notices pursuant to the agreement can be given to the broker. And so you can go ahead and you can do all of your legal work, and you can send all of your default letters, and you can even send your statement of claim via the brokerage. You'd have to really get permission from, because it's contrary to the rules of service. So you'd have to get permission for an order for substituted service that way. But the brokerage will act as your friend in that regard. But as to securing who the buyer is, I'm sure it's a good idea. I'll let your broker speak to it, but that's not normally done. Most people, if you are really worried about it, just make your deposit payable forthwith, as opposed to upon acceptance and within 24 hours. Just give me your deposit check along with your offer, if that's a real worry for you.
Understood. Thank you so much.
All right, what's your next question, guys? Anyone else? Yeah, go ahead, Lisa.
I just want some clarification regarding spousal support or spousal consent. Again, regarding common marriage. In the RIA courses, of course, we're told, to protect our butts by making sure if there's someone that's been living together for 3 years, to have them sign off the spousal consent.
So as someone who has taught the OREA course, particularly the law course, for over 7 years, I will tell you that that's not what we have said. You get a spousal support, you get a spousal signature for marriage only. That isn't to say that there isn't a whole range of other things, but for the purposes of the spousal signature, you can take it. I'm video recording this. You can blame me. I'm telling you straight out, it is married spouses only who sign that line. Okay?
Yeah.
If I can add a little trick to the people that are on here, the little trick that I teach realtors is no white lace dress, no signature. I know that sounds a little sexist, but in other words, somebody had to wear a white lace dress and walk down an aisle. In other words, there had to be a lawfully recognized ceremony. And here's the thing. You may have been taught by someone that just get it just in case it can't hurt. Yes, it can hurt. Because if they are selling this property and they're common law and they are in conflict, by you adding their signature, that can indicate to a court some other argument. So in other words, only put on what you have to put on that, but don't add anything because you think it can't hurt. So white lace dress, there was a ceremony, get a signature. Other than that, don't.
Well, that seems pretty declarative right there. All right. What else, guys? Last question. It's 10:04. You have one more question. Who's coming up with the last one? Keep in mind, if you do ask the last question, I get to give a drum roll beforehand so that it's a really dramatic question for the last one. So who's doing it? I'm doing the drum roll. I'm ready to go. Drum roll. Hit it. That's it? That's how we're leaving this? All right, fine.
Sorry,
all
Mark,
right.
I'll jump in and do the last question.
Oh, hold on, Chanel, hold on. Go for it.
Go for it. Amendments. Is that if there is amendment after the agreement of purchase and sale have been signed, let's say the closing date needs to be changed, as lawyers, do we just do it between ourselves, or do we ask the realtors to draft an amendment?
Well, I mean, it doesn't really make a difference. Both the realtors and the lawyers have the ability, but if you're asking as a lawyer, generally, if it's anything contentious, I take it on as a lawyer. If it's anything if it's just like a simple closing date change and it's still a month out, great. But if it's a last minute amendment, if it's something within the last week, I always do it through my office, particularly because there's usually costs that are associated that should be captured that the agents don't capture. And secondly, if it is in any way contentious or something that is not just plain on its face, then I usually do it through the lawyer's office as well. So it's perfectly acceptable to have agents do it for like minor, small changes, change a title search date, whatever it is, no problem. If it's anything contentious or if it is close to closing, as a matter of good practice, the lawyer should be doing it just to make sure that they're encompassing the costs.
And we don't need to do an amendment. We can just agree between the lawyers, purchaser and seller that, hey, we're extending the date, and they write back an email saying confirmed, we agree, and we're good to go? Or do we have to?
That is valid because they're acting as agents pursuant to that is valid for reasons I don't want to go into. But yes, that is a valid way of doing it because of the appointment of the lawyers as the designated agents and the DRA and a bunch of other things. So yes, it's acceptable to do it by way of correspondence. But technically the best way to do it is by virtue of an amendment, but that's not the way it's done in practice.
Yeah, because we don't have access to all your tools in the
Ex-
OREO forms. Thank you so much.
Exactly. Okay.
But to the rest of the group, though, I would caution, run every amendment to the closing date by the lawyer, because you don't understand the implications. Let the lawyers handle it. They can come back and say, no, you go ahead. But there could be little tiny nuances that they know about that they haven't discussed with you.
That's true. That's true. Listen, if it's anything substantive, once the agreement is with the lawyer and the agents should be working collaboratively, and use a lawyer that works collaboratively with you. You'll find yourself better off. Like Lauren. Lauren's a great lawyer. There we go. There you are. All right. All right, Lauren, shout out to Lauren. By the way, every single session we do should end with a shout out to Lauren. That's just the general rule here. All right, guys. We are golden. This will be posted. Thank you everyone for your attendance. And I will post the notice to new agents as to the meet and greet that we are going to be establishing to allow you guys to have your networks flourish, such that we have the end of August meet and greet scheduled shortly. Take care, everyone, and thank you all for attending.